Welcome and thank you for joining us today. The topic of our webinar is Current Trends in Prospectus Filings, what SME issuers need to know. My name is Jeff Scanlon. I'm a lawyer in the Corporate Finance branch of the OSC, and I'm the coordinator for the SME Institute this season. I'm delighted to introduce our speakers for today's session. Jesse Gill is a legal counsel in our Corporate Finance branch. Lorraine Greer is a review officer in our Corporate Finance branch. Evelina Barsikov is a review officer in our Corporate Finance branch. Jim White is a senior geologist in our Corporate Finance branch. David Mendocino is a senior legal counsel in our Office of Mergers and Acquisitions. And finally, Ray Ho is a senior accountant in our Corporate Finance branch. We will send evaluation forms at the end of the session, and we'd appreciate your feedback on this session. We'll also be sending CPD certificates via email after the session. Before we begin, I'd like to remind participants that the views expressed in this presentation are the personal views of the presenting staff and do not necessarily represent the views of the Commission or other Commission staff. The presentation is provided for general information purposes only and does not constitute legal or accounting advice. Information has been summarized and paraphrased for presentation purposes, and the examples have been provided for illustration purposes only. Responsibility for making sufficient and appropriate disclosure and complying with applicable securities laws remains with the company. Information in this presentation reflects securities laws and other relevant standards that are in effect as of the date of the presentation. The contents of this presentation should not be modified without the express written permission of the presenters. The objective of the OSC SME Institute is to support small and medium-sized businesses in facilitating cost-effective compliance through issuer outreach and education. It's important for issuers to know securities regulatory requirements and to help them navigate regulatory waters. The idea is that if we can help issuers to better understand their securities regulatory obligations, they can focus their resources on building their company. Ultimately, we both have the same goal: for issuers to provide appropriate and meaningful information to investors and stay onside regulatory requirements. It's important to remember that at the end of the day, investor confidence in the information that companies provide is critical to the success of the company. Today, we'll be walking you through some key topics, including a general overview of types of prospectuses and offerings, prospectus filing and review process, prospectus procedural requirements, timing and fees. We'll also discuss a variety of hot-button issues in prospectus reviews: financial condition and sufficiency of proceeds, financial statement considerations, forward-looking information, mining disclosure issues, and dual-class structures and restricted securities. And finally, we'll discuss reducing regulatory burden and some of the prospectus initiatives the CSA is working on. At this point, I'd like to hand it over to Jessie so that she can discuss prospectuses and their review process.
Thanks, Jeff. So I'm Jesse Gill, legal counsel in the Corporate Finance branch, and I'll be going over the first two topics. So Section 53 of the Ontario Securities Act states that no person or company shall trade in a security if the trade would be a distribution of the security unless a prospectus is filed and a receipt has been issued by the director. The Corporate Finance branch of the OSC reviews prospectuses filed by reporting issuers that cite Ontario as their principal regulator. We review these prospectuses for compliance with disclosure requirements as investors use these documents to make an investment decision on the offering. We also review these documents from a public interest perspective. The prospectus process allows for scrutiny by a regulator of the documents prior to the public relying on them. A prospectus can be a key investor protection tool because it can provide investors with important information about the company and the securities being offered. The information disclosed should be both comprehensive and entity-specific, and provided that the information disclosed is balanced and does not use boilerplate language, a prospectus should assist investors in evaluating the performance and risks of the company so that they can make an informed investment decision. OSC staff conduct a review of the prospectus and issue comments to address disclosure deficiencies or other substantive issues. There are a number of possible outcomes from a prospectus review, and more than one outcome can be associated with a particular file. Possible outcomes from a prospectus review include material disclosure changes, the correction and refiling of significantly deficient continuous disclosure filings that an issuer incorporates by reference. After the review is complete and assuming all issues have been resolved, staff will generally recommend that the director issue a final receipt for the prospectus. There are a number of scenarios where Section 61 of the Act provides that a director shall not issue a receipt. These include instances where there is substantial non-compliance with securities law requirements, where the issuer's business may not be conducted with integrity and in the best interests of security holders because of past conduct of officers and/or directors, and lastly, where the aggregate of the proceeds from the offering and other resources of the issuer are insufficient to achieve the purpose of the offering. We'll specifically discuss sufficiency of proceeds concerns later in the presentation. Apart from these instances, it is generally expected that a director will issue a receipt unless the directors believe it is not in the public interest to do so. When raising money in the public markets, a prospectus must be filed with the securities regulatory authorities. Exemptions from the prospectus requirement are available for those who wish to raise money privately. Commonly used prospectus exemptions include the accredited investor exemption and the friends and family exemption. These and other prospectus exemptions are set out in National Instrument 45-106 Prospectus Exemptions. So there are various types of prospectuses that an issuer may file. I will briefly describe each of them. A long-form prospectus is used by a company completing an initial public offering of its securities, commonly referred to as an IPO, or a company that is not eligible to use a short-form prospectus. Small and medium-sized enterprises that do not have a current annual information form are generally required to file a long-form prospectus. This involves the filing of a preliminary prospectus and a final prospectus. From the date the preliminary long-form prospectus receives a receipt from the director, generally upon filing, the Principal Regulator has 10 business days to conduct a full review and issue comments. Companies must comply with the specific disclosure items set forth in National Instrument 41-101 and its related form. For an initial public offering, a company becomes a reporting issuer following the issuance of a final receipt on its prospectus, and going forward they would be subject to continuous disclosure, which I will refer to as CD, obligations pursuant to National Instrument 51-102 CD obligations. A short-form prospectus is used by a company that is already a reporting issuer in a Canadian jurisdiction and that meets the eligibility requirements that are set out in National Instrument 44-101. These requirements include an existing CD record and equity securities listed on a qualified exchange. When filed, short-form prospectuses go through a screening process and are either assigned to a basic review, an issue-oriented review, or a full review. Generally, staff has 3 business days to issue comments in the context of a short-form prospectus. A short-form prospectus must comply with National Instrument 44-101 and its related forms, which allow existing reporting issuers to incorporate certain information into a prospectus, including financial statements and management's discussion and analysis, an annual information form subject to certain exceptions, and material change reports. The short-form prospectus rules also allow for deemed incorporation by reference of all documents filed after the final prospectus, but before completion of the distribution. These documents would form part of the prospectus and potentially attract liability. A prospectus must provide full, true, and plain disclosure of all material facts relating to the securities issued or proposed to be distributed. Where a prospectus or any amendment to the prospectus contains a misrepresentation at the time of purchase, a purchaser who bought a security offered during the period of distribution is deemed to have relied on the misrepresentation and as such has a statutory right of action for damages against certain persons. A base shelf prospectus is a form of prospectus used by a company that is already a reporting issuer. If a reporting issuer is eligible to file a short-form prospectus, then it also meets the technical eligibility requirements to file a base shelf prospectus. Note that there are some instances in which the use of a base shelf prospectus may not be appropriate. We will discuss these later in the presentation. A short-form base shelf prospectus allows a reporting issuer to qualify and distribute various types of securities over a 25-month period up to the stated dollar value of securities shown in the final prospectus. This form of offering allows a company to access the capital markets quickly because it can draw down from the aggregate amount indicated in the base shelf prospectus by filing a prospectus supplement that includes the details of the offering. Base shelf prospectuses are cost-effective ways for issuers to access the public markets. Certain information relating to the particular offering may be omitted from a base shelf prospectus, provided that it is included in the prospectus supplement, which is filed and delivered when the actual distribution of securities occurs. A post-receipt pricing prospectus, or PREP prospectus, allows a reporting issuer to obtain a receipt for a final prospectus without pricing details. A supplemented PREP is then filed containing the pricing information. This type of prospectus is usually used by reporting issuers doing a cross-border financing, since it allows Canadian dealers to coordinate timing with U.S. dealers. The Canadian-U.S. multi-jurisdictional system was adopted in 1991 by the Canadian Securities Administrators and the U.S. Securities and Exchange Commission. The MJDS is a disclosure system that enables eligible cross-border securities offerings to be governed by the disclosure requirements of the issuer's home country. MJDS is mostly used by international issuers who are offering securities and have a shareholder base in Canada and in the U.S. In terms of offerings, MJDS has two parts: southbound MJDS, used by eligible Canadian reporting issuers who meet MJDS requirements to sell their securities into the U.S., and northbound MJDS, used by eligible issuers to sell their securities into Canada. Canadian reporting issuers who meet MJDS requirements set forth in National Instrument 71-101 are permitted to file a Canadian short form prospectus in both Canada and the U.S. The rules are similar for U.S. issuers filing in Canada under National Instrument 71-101. There are generally 6 types of offerings available to issuers. The first is a bought deal offering. A bought deal is where underwriters price the deal and sign a firm commitment with the issuer to buy the base amount of securities 4 days prior to filing a preliminary prospectus. A preliminary prospectus must then be filed not more than 4 days after the entering into of the underwriting agreement. An overnight marketed deal begins with an issuer filing a preliminary prospectus and receiving a receipt. Then the underwriters market the deal overnight at the close of the market on the date a preliminary receipt is issued. The next morning, the underwriters will price the deal and sign a firm commitment to buy a base amount of the offering. An amended and restated preliminary prospectus is then filed with the size and pricing information provided. For a fully marketed underwritten deal, the underwriters will price the deal and sign a firm commitment to buy the base amount of the offering on the eve of the filing of the final prospectus. This is usually the IPO scenario. There are 2 types of best efforts agency offerings. The first is where the agent must sell between a minimum and a maximum dollar value of securities. The second is where the agent will sell the offering using best efforts, but the deal is not contingent on a minimum dollar value being sold. Given that the agent is selling the offering using their best efforts, the agent is not liable to buy any unsold securities. In a special warrant offering, special warrants are issued to investors pursuant to a prospectus exemption before a prospectus is filed. The special warrants are convertible into underlying securities of the issuer, for example, common shares, and the reporting issuer is required to file a prospectus to qualify the distribution of underlying securities. The last type of prospectus to discuss are non-offering prospectuses. Non-offering prospectuses do not involve the selling of any securities to the public. Sometimes a company wants to list on an exchange or become a reporting issuer without conducting an IPO, so the company doesn't want or need to raise money by way of prospectus at the current time. This approach can save a lot of time and money because an underwriter is not involved in the process. So moving on to discuss the prospectus filing and review process, this is meant to give a very high-level overview of what can be expected when filing a prospectus with the OSC. Note that additional detail on this process will be provided by Lorraine and Evelina in the next section entitled Prospectus Procedural Requirements, Timing, and Fees. We'll go through the topics listed on this slide. This is an overview of the process, including the steps that are taken before a final receipt is issued. As you can see, an issuer would start off by determining the principal regulator, then file a pre-file or application, if applicable, and I will discuss this in more detail in a minute, followed by filing of a preliminary prospectus. A preliminary prospectus will be reviewed by OSC staff and comments may be issued. Once all of the comments have been addressed, the issuer would be cleared to file a final prospectus. After review of the final prospectus and associated documents, a final receipt would be issued. An issuer needs to determine its principal regulator. You can refer to National Policy 11202, Process for Prospectus Reviews in Multiple Jurisdictions for more guidance on how to determine your principal regulator. Generally, the location of an issuer's head office will be determinative if the head office is in one of the specified jurisdictions listed on this slide. However, in a situation where an issuer's head office is not located in a specified jurisdiction, the other listed factors will be relevant in determining with which of the specified jurisdictions the issuer has the most significant connection. The purpose of having a principal regulator is so that an issuer generally only has to deal with a single regulator when it files a prospectus or its CD documents. Non-principal regulators will generally rely on the PR to monitor and enforce compliance as appropriate. In the event that there are certain novel aspects to a file or a significant or unique matter that an issuer feels should be discussed with the regulator before a preliminary prospectus is filed, we generally encourage issuers to pre-file with us so that these issues can be addressed. The main benefit of pre-filing is to avoid surprises during the comment period and to understand how staff would interpret certain matters prior to filing a prospectus. It is important to keep in mind that the length of time for a pre-file review depends on the complexity and the novelty of the issues. Pre-filings and applications are reviewed on a case-by-case basis and are dependent on the specific facts and circumstances. We generally do not consider time and cost as reasons for non-compliance with the prospectus requirements. We do consult with other CSA jurisdictions on novel issues, which is another reason why any novel aspect should be pre-filed, as this process can be quite lengthy. Lastly, in the event that relief from certain requirements is granted, we would expect a description of the relief to be discussed and disclosed in the prospectus. The next step in the process is to file the preliminary prospectus. It is important to properly file all of the applicable documents to ensure a preliminary receipt is issued in a timely manner. A list of the required documents is located in the relevant national instrument governing the type of prospectus being filed. Documents include an English version of the prospectus, as well as a French version if filed in Quebec, a qualification certificate, material incorporated by reference, documents affecting the rights of security holders, such as bylaws, material contracts, reports, valuations, and mining reports. These are the documents that are required to be delivered to the regulator but not filed. The distinction is that documents delivered to regulators are not made public on SEDAR, but they are necessary for the principal regulator to complete their review. The items on this slide should be considered when filing the materials associated with a preliminary prospectus. The date of the prospectus should coincide with the date of the filing, so within 3 days. If all required documents are properly filed and delivered before noon, a receipt for the preliminary prospectus would generally be issued on that day. It is also important to note that if there is a material adverse change to the prospectus, an amended and restated preliminary prospectus should be filed to incorporate those changes. A material adverse change is essentially a change in the business operations or capital of the issuer that would reasonably be expected to have a significant negative effect on the market price or value of any of the securities of the issuer. Again, these are the timeframes for which a comment letter should be expected. Some tips for responding to comment letters include making sure the responses comprehensively address staff's comments, citing authoritative references and precedents where possible, providing proposed disclosure to be included in the prospectus which would address staff's comments. Similar to preliminary prospectus filings, these are the required filings for the final prospectus, which include English and French translation of the prospectus if applicable, material incorporated by reference, documents affecting the rights of security holders, again, these might be bylaws, material contracts, reports and valuations, and undertakings, submission to jurisdiction for both issuers and directors, and expert consents. The documents required to be delivered include a black line which shows changes from the preliminary prospectus and a conditional approval letter from the exchange. Other considerations for filing a final prospectus include the time between the date of the preliminary prospectus and the date of filing the final prospectus. There is generally a 90-day deadline. If you are worried that you won't meet the 90-day deadline, consider, in advance of the 90th day, whether it would be appropriate to file an amended and restated preliminary prospectus to reset this timeline or apply for timing relief. In order to receive a receipt of a final prospectus on a particular day, the final materials need to be filed before noon on that day. Furthermore, any issues noted in the filings could delay the final receipt. It is important to keep in mind that if a material change occurs after filing of the final prospectus, but before the completion of the distribution under the final prospectus, then an amendment to the final prospectus should be filed in order to incorporate these changes. So now I'll be handing it over to Lorraine and Evelina.
Hello, my name is Lorraine Greer, and I am here with my colleague, Evelina Barsukov. We are the Prospectus Review Officers in the Corporate Finance Branch. We conduct the initial and preliminary prospectus reviews and issue receipts. In this section of the presentation, we will discuss the procedural requirements, timing considerations, and filing fees and fee codes related to prospectuses. For each prospectus filing, an issuer must have a Principal Regulator who will issue the receipt for the prospectus. The Principal Regulator, which we will refer to as PR, must be one of the 8 specified jurisdictions noted on this slide. However, the prospectus can be filed in all Canadian provinces and territories. A PR must be chosen on SEDAR even when the issuer is not yet a reporting issuer. Please note, in determining your PR, you must first use the head office location. Generally, if the head office is in one of the specified jurisdictions, this jurisdiction will be the Principal Regulator. In general, the head office will be determinative of PR in almost all cases. The location of the registered office or its mailing address are not acceptable. If you are unable to determine the head office and the issuer does not yet have a PR, please refer to National Policy 11202 to review the list of connecting factors. As you can see, the last 3 connecting factors are different because they only apply to foreign issuers and only when the previous factors do not apply. The first connection to a specified jurisdiction establishes the PR. In other words, stop at the first relationship you are able to establish. When filing a non-investment fund prospectus on SEDAR, these are the correct selections to make. When in doubt, please refer to this structure. On this slide, you can see which mistakes will lead to the refiling of the entire set of documents under a new project and what will allow you to refile only 1 or 2 documents. If there are errors in any of the following, project number, filer category, filing category, or filing type, the prospectus will have to be refiled under a new project number, whereas an error made in the filing subtype or document type can be corrected on the same project. For any of these errors, you will be asked to refile. However, if you have already paid the prospectus-related fees, there is no need to pay again. A cover letter explaining the error should always accompany a refiling and, if applicable, authorize us to transfer the fees from the incorrect project to the correct one. Before getting into specific documents, we want to highlight that if filing in Quebec, you must file French versions of the prospectus and any documents incorporated by reference everywhere the prospectus is being offered. Before submitting the French version, ensure the text is legible and that the dates and signatures match the English version. If the issuer has an exemption from filing furnished documents, it should be noted in the cover letter and the preliminary prospectus. There are certain documents that are required with any type of prospectus filing, such as the prospectus itself, cover letter, National Policy 11202 confirmation letter, and PIFs. There are also special documents related specifically to long and short forms. We require all documents to be accurate, complete, and current to avoid undue delays. Be aware of the difference between filed and delivered. Documents required to be filed will generally be made public, prospectus and any material contracts, for example. Those required to be delivered will generally remain private, PIFs and the auditor's comfort letter, for instance. See National Instruments 41-101 Part 9 and 44-101 Part 4. And now let's take a look at a few of these documents. We will begin with some of the requirements specific to the long form prospectus. The first one on the list is documents affecting the rights of security holders. For your reference, we have provided details of what is required for this filing. One of the common and consistent errors we see with these documents is that they contain manual signatures. Remember that these documents will generally be made public, so we will only accept conformed or electronic signatures. The next item is material contracts. Any of the material contracts not previously filed with the Commission should be filed with the prospectus. If there is a draft escrow agreement, it must be mentioned in the prospectus and submitted with the filing. Please note that these documents cannot contain any redactions, and, as mentioned previously, conformed signatures are mandatory. Last but not least, for the long form is the auditor's comfort letter. The letter must always supplement the long form submission in instances when the auditor's report in the prospectus has not been signed. It must have a proper reference to the prospectus date, name of the issuer, and its financial statements. Now let's go over some document requirements for the short form prospectus. Here, the first point on the list is notice of intention. For an issuer to be short form eligible, it must be either grandfathered or it must file a notice of intention at least 10 business days prior to filing its preliminary prospectus. Filing such notice triggers an automatic change of status on the issuer's SEDAR profile. A notice of intention is only required to be filed once, and it is effective until withdrawn. The qualification certificate must also be filed with each short form prospectus. It verifies the eligibility of the issuer to file a short form. Such certificate must be signed by an executive officer, as defined in the Securities Act. Ensure that the date and jurisdictions on the certificate coincide with the date and jurisdictions on the prospectus. The last document we will discuss for short forms is documents incorporated by reference, or DIR, which are the continuous disclosure documents such as financial statements, management discussion and analysis, press releases, annual information form, etc. These documents must be filed in each jurisdiction where the prospectus is filed. If any of the jurisdictions have been erroneously omitted, then the applicable documents must be filed on the same SEDAR project in the jurisdictions that were missed. When listing them in the prospectus, it is helpful to always have a reference to the filing date of the documents. I will now turn the presentation over to my colleague, Evelina.
Thanks, Lorraine. I will be covering confirmation letters, red herrings, certificates, PIFs, and timing and fees. So let's begin. Not all prospectuses are filed in multiple jurisdictions, but if they are, you must deliver a confirmation letter. In National Policy 11202, you must confirm that items A, B, and C, referring to everything being filed and delivered, fees haven't been paid, and that the issuer is in good standing, are satisfactory. If some of the options are not applicable to your filing, they should be acknowledged as such in the letter. For example, D, E, F are not applicable. Submit the confirmation letter using the correct SEDAR document type, and do not make it a part of the cover letter. Moving on to red herrings and certificate language. For your convenience, we have paired them up. Because every prospectus must be endorsed by the issuer's management team, certificates are an essential part of the prospectus. The following few slides will cover long and short forms, as well as shelf and prep alternatives. It is important to be consistent when identifying jurisdictions in both the red herring and certificate pages. The same, of course, goes for the short form prospectuses. A shelf prospectus will have more options for you to choose from for the certificate language, based on the circumstances of the distribution set out in it. A prep or post-receipt pricing prospectus, as you know, refers to a price being determined after a final receipt has been issued. Because there are 2 stages to the process, each stage calls for a different certificate. In the first stage, the preliminary and final prospectuses will bear the same certificate language, whereas in the second one, the supplemented version, a different wording will be required. Now we're going to talk about the personal information forms, or PIFs. They are an essential part of every preliminary prospectus filing and must be submitted together with it. PIFs are required for officers, directors, and promoters, insiders of the company. The main form of PIF we review is the CSA PIF. However, the other types of PIFs are also acceptable. A certificate and consent form must always accompany one of the acceptable PIFs. When filing with the exchange, in the case of a CPC, a TSX declaration can be submitted. A TSX declaration is the form of the consent used and accepted by the venture exchange. However, when the documents are concurrently filed with the OSC, this declaration does not replace the requirements to file the certificate and consent under National Instrument 44-101. There are many common deficiencies which will lead to refiling of a PIF and may slow down the review process. We want to stress the importance of checking PIFs before submitting them. That means even previously delivered PIFs should be vetted. In such case, a reference to its location must be given in the cover letter. If there is a positive response to any of the questions in parts 6 to 10, a detailed explanation must be provided as an attachment. The attachment must be initialed by the insider. When the name of the insider and their date of birth are handwritten, such responses must be legible, correct, and complete. No initials, shortened, or nicknames are acceptable. If there has been a name change, any prior names should also be provided. All sections must be completed and all questions must be answered. Not applicable is reserved as response only for a few of the questions. You can see the PIF form for more details. We often get asked whether a PIF submitted for another issuer can be utilized by the same insider, and our answer to this is that in most cases it can be. However, whenever you are submitting it for the issuer at hand, ensure that the issuer name is correct. As previously mentioned, a certificate and consent must accompany and must be attached to the PIFs being submitted. If you cannot make changes to a PIF, or you are not sure which SEDAR submission it is under, we strongly suggest that you submit a new one. We're also often asked about timing of receipts. This table provides you with a quick reference guide. We do realize that there can be extenuating circumstances when you might require special accommodation in terms of timing. In this case, please email us as soon as possible, before noon, on the day you require a receipt. However, please note that all such requests will be reviewed on a case-by-case basis, and we cannot guarantee that the receipt will be issued at the time requested. On the next 3 slides, we will cover general receipt timing, bought and overnight market deals. The goal of a prospectus filing is to obtain a receipt. For general prospectus receipt timing guidelines, it is important to stress the fact that if a prospectus is filed before noon, then a receipt most likely will be provided on the same day. Generally, if the prospectus is filed after 12 o'clock, then a receipt will be issued before noon on the next business day. Please note that all receipts will bear the date of issuance on them. And since we're talking about prospectuses and timing, it is important to remember that any prospectus must not be filed by an issuer later than 3 business days after the date of the prospectus. For example, if the date of the prospectus is February 21st, 2019, which happens to be a Thursday, then your deadline to file would be Tuesday, February 26, 2019. Further, the dates of the accompanying documents must coincide with the prospectus date. When we're talking about bought deals, here are 2 deadlines for you to consider. First of all, please contact us before noon to notify us that you will be filing. After that, 3 p.m. becomes the second deadline and the latest time when we will accept the prospectus filing in order for you to receive the preliminary receipt the same day. Please remember to indicate the issuer's reliance on Section 7.1 of National Instrument 44-101 in the cover letter. Email is the most efficient way to contact us. By email, and as early as possible on the day of filing, similar to the bought deal scenario, an issuer must advise us of its plans to conduct an overnight marketed deal. To ensure that we have enough time to advise you if there are any deficiencies, submit the filing via SEDAR no later than noon. We will make reasonable efforts to issue the receipt after markets close. In other words, at or after 4 p.m. of the same day. If these timing guidelines are adhered to, then we will use our best efforts to issue a receipt on the same day. Otherwise, the receipt will be issued and dated the next business day. The same OSC staff notice applies to this situation. And the last area we will cover is fees. When paying your filing fees through SEDAR, select the appropriate prospectus type and fee code. You can see from the table that there are only 3 to choose from. If you are filing for a mining or resource issuer, a fee must be paid for each technical report filed with or incorporated indirectly or directly into the prospectus. If fee codes have been applied correctly, a letter must be submitted on SEDAR under the same project number, requesting that the fees paid on the incorrect code be applied to the correct code. A quick note, if a fee has been paid on a prospectus pre-filing, no further fees are required for the related prospectus. The fee for the pre-filing will be applied to the prospectus. However, an exemptive relief application is a separate process. No prospectus can or will be processed, and receipt will not be issued without the payment of the OSC's prospectus filing fee, which is currently $3,800. That's it for our portion of the presentation. We hope we have covered some of the most frequently asked questions, most common filing and procedural errors that may cause delays or refiling. This slide provides you with our contact information. Our contact center can answer most of your general filing questions. We have also included our emails if you have specific questions regarding the filing of your prospectus. Thank you for listening. And now I'm going to hand over things to Ray.
Thanks. Now I'll move on to the topic of sufficiency of proceeds and concerns regarding the financial condition of an issuer in the context of a prospectus filing. These slides identify common areas of consideration, but staff will review the particular facts and circumstances on a case-by-case basis. The sufficiency of proceeds from the offering and financial condition of an issuer are key areas that staff consider in each prospectus review. Under securities legislation in Canada, a decision maker, which in this case would be the Director of Corporate Finance, shall not issue a receipt for a prospectus in specified circumstances. In particular, a decision maker is prohibited from issuing a receipt for a prospectus if it appears that the proceeds from the prospectus offering, along with the issuer's other resources, will be insufficient to accomplish the purpose of the issue stated in the prospectus. There may be receipt refusal concerns when it appears that the prospectus inadequately describes an issuer's financial condition and going concern risk, or there is adequate disclosure about the issuer's financial condition, but it appears that there are sufficiency of proceeds concerns. Therefore, a critical part of our review of every prospectus is considering the issuer's financial condition and intended use of proceeds. Some areas we consider as part of our review include: can the issuer reach the next milestone in their development plan? Does the issuer have enough money for working capital requirements or any repayments of debt coming due in the near term? Does the issuer have enough money to advance the business? I'll note that our expectations depend on the stage of operations the issuer is in. For example, we have different expectations for a fully operational company that is earning revenue as compared to a research and development stage company. I will discuss this in further detail later in the presentation. When conducting our review, we may consider the anticipated proceeds from an offering to be insufficient in several cases. This slide lays out some of the offering structures where we have seen many examples of concerns regarding sufficiency and certainty of proceeds, a best efforts without a minimum, or base shelf prospectus. we may view the proceeds as being insufficient if they will be raised through a best efforts offering without a minimum subscription, or a minimum subscription that does not appear to be sufficient to satisfy the issuer's short-term liquidity requirements. Additionally, we may have concerns when an issuer files a base shelf prospectus, which can be drawn down in small increments because when considered separately, the individual drawdowns may not be sufficient to satisfy the issuer's short-term liquidity requirements. There's nothing inherently wrong or bad with these offering structures, and they may be appropriate in some cases. Issuers and their advisors should consider how the offering structure affects our concerns about the financial condition and sufficiency of proceeds given the issuer's specific facts and circumstances. So why do we focus on sufficiency of proceeds in our reviews? A principal purpose of the sufficiency of proceeds receipt refusal provision is to protect the integrity of the capital markets, which would be harmed if an issuer ceased operations due to insufficient funds shortly after completing a prospectus offering. We want issuers to be able to demonstrate that they have sufficient resources to meet their short-term liquidity requirements. The relevant time frame for this will vary depending on the type of issuer. Some guidelines are included in the table on the slide. An exploration stage issuer should have sufficient resources to reach completion of the next phase of a project. A development stage issuer should have sufficient resources to achieve their next significant milestone. A research and development issuer should have sufficient resources to achieve progress on the development of a key product. And an issuer with active operations should have sufficient resources to continue operations for the short term, which staff usually view as 12 months from the date of the prospectus. A subtle key point on this slide is that you have to have sufficient resources to advance the business during this period. Keeping the lights on isn't sufficient. You have to be able to advance the business. As discussed earlier, issuers have different options available to them in terms of the form of prospectus they file. We are going to look at some concerns related to sufficiency of proceeds and financial condition that may arise when issuers choose to file a base shelf prospectus. As a reminder, a base shelf prospectus can only be used by a company that is already a reporting issuer now. It allows companies to access capital markets quickly because they can draw down or raise small amounts of capital in increments for up to 25 months. Therefore, many issuers see it as a cost-effective way of accessing markets. However, staff may take the view that a base shelf prospectus is not appropriate given the issuer's financial condition and uncertainty of financing, particularly when the issuer does not have sufficient funds at the time of the filing of the base shelf prospectus to meet its obligations for the next 12 months. When staff has these type of concerns, we may request submissions in a number of areas as outlined on this slide, such as the issuer's rationale for filing a base shelf prospectus, whether the issuer intends to file a prospectus supplement in the near future, and if so, the type of securities to be offered, the proceeds that are contemplated to be raised and how they will be used, the availability of other sources of financing to provide working capital and fund the issuer's business if sufficient financing cannot be raised, the proposed nature and timing of the offerings under the base shelf prospectus, including any involvement of an agent or underwriter, the use of a minimum subscription amount below which an offering will not proceed, the specific use of proceeds for offerings completed in the next 12 months, and details regarding concrete development milestones that would advance the issuer's business objectives and are expected to be completed in the next 12 months. In order to address the concern that incremental drawdowns may be insufficient to satisfy an issuer's short-term liquidity requirements, we may request that the issuer do a number of things, including changing the structure of the deal by withdrawing the base shelf prospectus and instead filing a short form prospectus with a minimum subscription amount that is sufficient to meet the issuer's short-term liquidity requirements, or filing a short form prospectus with a fully underwritten commitment. We may also ask the issuer to arrange for additional sources of financing to satisfy our concerns. Keep in mind that each situation is different, and staff will evaluate the individual circumstances of a particular file to determine the acceptable course in that situation. Now let's touch briefly on the relevant disclosure when staff has concerns over the financial condition of the issuer. A prospectus must contain clear disclosure on how the issuer intends to use the proceeds raised in the offering, as well as disclosure of the issuer's financial condition, including any liquidity concerns. This disclosure is important to investors because it provides warnings about significant risk that the issuer is facing or may face in the short term, and may help investors avoid or minimize negative consequences when making investment decisions. In particular, the issuer should disclose prominently in the use of proceeds if it has had negative cash flow from operations in the most recent annual audited financial statements, as well as corresponding risk disclosure. Other relevant information in this context may include disclosure of a working capital deficiency. We often request issuers with working capital deficiencies to disclose the working capital deficiency at the most recent month end in the prospectus, and we expect the proceeds of the offering to cover any deficiency. I'd like to highlight the fact that disclosure on its own may not be sufficient to satisfy receipt refusal concerns in certain circumstances. In other words, if the proceeds are insufficient to accomplish the purpose of the issue, this would give rise to a receipt refusal concern regardless of the disclosure. In addition to changing the structure of the offering or the disclosure in the prospectus, issuers may also structure their affairs in a way to help address our concerns. For example, issuers may obtain alternate financing or renegotiate the maturity date of a loan to ensure that they will have sufficient funds in the short term. If this needs to be done to address our concerns, we expect that it is subject to a definitive agreement and described as such in the final prospectus. The final slide in this section is provided primarily as a reference slide. It includes some, but not all, of the specific provisions that are applicable to the disclosure required in a prospectus regarding the use of proceeds and the financial condition of the issuer. I would highlight the last bullet, Staff Notice 41307. CSCA staff have previously issued a comprehensive staff notice which outlines our approach with their concerns regarding the financial condition of an issuer and sufficiency of proceeds in a prospectus offering. Staff Notice 41307 is a key resource that issuers can use to understand staff's approach in this area. The staff notice is available on the OSC website. I will now move on to financial statement considerations in prospectus filings. Starting with a financial history for IPO or long-form prospectuses, there are a few questions to consider. First is, what periods of financial history are required for an IPO prospectus? Item 32 of Form 41-101F1 describes the financial statement disclosure required in IPO prospectuses. The amount of financial history differs slightly between non-venture and IPO venture issuers, which I will discuss in more detail in the next slide. The other important item to consider is what actually comprises the issuer's entire business. An issuer needs to consider the business that investors are investing in, even if this financial history spans multiple legal entities over those periods. This means that an IPO prospectus must include financial statements for acquired businesses or proposed acquisitions if these businesses are regarded as being the same primary business, meaning that they pursue the same activities in the same business. For example, if a REIT was comprised of 30 properties, we would expect financial statements for all 30 properties for the entire period required under Item 32. Depending on the facts and circumstances and the ownership structure, this could be represented in one set of financial statements for all 30 properties, or it could be a number of financial statements on a vendor-by-vendor basis. In instances where there are multiple acquisitions in the same primary business of the issuer, and the issuer is unable to comply with securities law, we encourage issuers and their advisors to consult with staff on a pre-filed basis before a preliminary prospectus is filed to consider if financial statements of any smaller acquisitions could potentially be excluded from the prospectus via exemptive relief if the acquisitions are not material. I also want to remind you that an MD&A is required for every set of financial statements included under primary business, and that an acquisition could meet the definition of an asset acquisition under IFRS, while the same acquisition could also be considered a business acquisition for securities law purposes. So even though an acquisition could be an asset acquisition under IFRS, financial statements of the predecessor may be required under securities law. We generally consider the acquisition of a separate entity, a subsidiary, or division to be an acquisition of a business, and in certain circumstances, the acquisition of a smaller component of a company may also be considered an acquisition of a business, irrespective of whether or not financial statements were previously prepared for the business. This slide summarizes the general financial statement requirements under Item 32 of Form 41-101F1. The top half of the slide discusses requirements for annual financial statements. Whether you are an IPO venture issuer or a non-venture issuer, we require balance sheets for the last 2 years. With regards to income statements, cash flows, and statement of changes in equity, we require non-venture issuers to have 3 years and IPO venture issuers to have 2 years. In terms of interim financial statements, both IPO venture and non-venture issuers are generally required to provide interim financial statements for the most recently completed interim period after the most recent financial year. The key here, as this may affect the timing of your prospectus, is that for an IPO prospectus, irrespective of whether you are an IPO venture issuer or a non-venture issuer, the annual and interim financial statements are due 90 days after year-end and 45 days after quarter-end. If you are planning to be a venture issuer, you cannot take advantage of the longer time frame for annuals and interims until after the IPO prospectus. Generally, any primary business financial statements, including the prospectus, must be audited unless an exception applies. Exceptions to this requirement are found in Item 32.5 of Form 41-101F1. The most commonly used exemptions include Interim financial statements. The most recent interim financial statements included in the prospectus after the most recently completed financial year are not required to be audited. Another exception is for annual financial statements for the second most recently completed financial year of a junior issuer as defined under a National Instrument 41-101 if an auditor has not issued an auditor's report on those financial statements and the financial statements for the most recently completed financial year is not less than 12 months in length. It's important to note that any primary business financial statements that are not audited are required to be reviewed. We'll now turn our attention to forward-looking information, or FLI, as this is an area in which we've recently seen an increase in use in prospectuses. This slide provides a good overview of what is considered to be FLI, which is generally disclosure about possible events, conditions, or financial performance that is based on assumptions about future economic conditions and courses of actions. As you can see on the chart, FLI includes two subcategories dealing with financial information. On the bottom left, there's future-oriented financial information, also referred to as FOFI, and on the bottom right, there's financial outlook. The key difference between FOFI and financial outlook is the format in which the financial information is presented. In the case of FOFI, the information is presented in the format of a historical financial statement, while it is not for a financial outlook. Examples of a financial outlook would include projected EBITDA, expected revenue, profit or loss, EPS, or R&D spending. Another example of information that we consider to be FLI is an estimate of anticipated expansion of a business, such as estimates of future store openings by an issuer in the retail industry. We've seen a lot of this type of FLI in IPO prospectuses as issuers hope to convey their growth strategy within the prospectus. I also want to point out that if you disclose FLI, you are required to provide updates in your MD&A if results will materially differ from what was previously disclosed, as well as a comparison to actual if there's a material difference. This slide shows some of the key considerations and expectations when disclosing FLI. Is FLI identified? For example, has the issuer noted that projected revenue is forward-looking information? Is there a reasonable basis for the disclosed FLI? In determining what constitutes a reasonable basis for FLI, an issuer should consider the reasonableness of the assumptions underlying the FLI and the process followed in preparing and reviewing the FLI, as this could be misleading if not disclosed. Are the assumptions supporting financial outlook and FOFI reasonable, entity-specific, and disclosed? I.e., does the issuer disclose what the assumptions are that support the projected revenue figure? Is the FLI presented for a reasonable period? Has the issuer presented target revenues for multiple years? Have users been cautioned that actual results may vary from FLI? Have the risk factors that could cause actual results to vary been identified? Generally, the longer the period of FLI, the greater the likelihood that the forecast may not be viewed as reasonable. I wanted to highlight an example of FLI disclosure over a lengthy period, in the example on this slide, 5 years, without providing the underlying assumptions to support the FLI. In this example, the company simply discloses its 2018 actuals in the left column for revenue, EBITDA, and storefronts. In the same table, the company discloses targets that are 5 years out, showing significant growth of revenue, EBITDA, and number of physical storefronts. As you can see, this disclosure does not provide the underlying assumptions to support the growth targets disclosed. This is the same example, but modified to contain detailed assumptions underlying the revenue growth target. Note that the assumptions underlying the EBITDA and store location targets are also required. However, for the purpose of this example, I will just run through revenue. As you can see in this example, instead of disclosing targets that are 5 years out, the growth targets were reduced to 2 years. As in this case, 2 years was determined to be a reasonable time period, and the reasons for that are described as well. A growth target of 5 years, though in certain circumstances could be reasonable, should be considered carefully as it is difficult to reasonably project out 5 years and provide assumptions for a 5-year target. Furthermore, a company would need to consider the requirement to update the FLI in its MD&A. As you can see in the slide, the 2019 and 2020 revenue targets are based on growth target rates of about 20% each year. As described in the slide, this growth target is consistent with the annual growth rate achieved over the recent historical period. In addition, the company has signed lease agreements for new store openings in 2019 and 2020, which is a key reason for revenue growth in the next 2 years. This example provides investors with a clear understanding of how the company intends to reach its growth targets. Now I'll pass it over to Jim to talk about mining issues.
So this part of the webinar is meant to give you a general guide to the mineral disclosure required for a prospectus. We'll look at the use of proceeds having a complete and current technical report, and some pitfalls in preliminary economic assessments, getting the right QPs, and some possible problems with mineral resource estimates. For a prospectus to have full, true, and plain disclosure, any material mineral project has to be described. A long form will always trigger a technical report, and a short form may trigger one. The required disclosure is the same that would go in an AIF, whether the company is required to file an AIF or not. And that disclosure is also the perfect summary for a technical report. The report author should design his summary around that. And the use of proceeds is another section of the prospectus that's likely to entail mineral project disclosure. So the questions the use of proceeds has to answer are, what are you going to do? What are you doing it for? And when are you going to do it? So it's work plan, objectives, and milestones. If your plan is to do what's in the technical report budget, that budget can simply be dropped into the prospectus. If your plan is something else, then it needs a QP to sign off, and the QP will be an expert under the rule. The company is going to need an expert's consent for that. You'll want to get in front of possible financing opportunities, and there's nothing stopping you from planning that out in advance with your QPs. So if you have a work plan, a program planned in advance in consultation with a QP, that is going to help you anytime that you do get a financing window. You should provide a budget that investors can rely on, and your proceeds will need to get you to a milestone. If the work program goes beyond the recommendations in the technical report, you need to be ready with a breakdown of costs that shows investors what they should expect from you. And as for a base shelf, a junior company will only get one if it shows it can keep the lights on and get to a milestone. An incomplete technical report, that's a major pitfall. People seem to look past the requirement in the rule, but it is black and white. Current report must have all material information about the mineral property. That's right in the definitions. If not, it doesn't meet the definition of a technical report, and the QP can't truly certify that the report contains all material information. The case we see this most often is where a company thinks of itself as having a project at the mineral resource stage, but the property is one that was developed before, it has significant mine workings or infrastructure, or sometimes it even has a mill. And all of that information has to be described as well, even if in a normal mineral resource situation, you would need only to describe how you got a mineral resource. There are some objections that we hear in incomplete technical reports. Sometimes people say our project doesn't meet the definition of an advanced property. Well, an advanced property definition doesn't relieve you of the requirements in section 1.1 or 6.1 of the instrument, or the requirement that a QP is certified that the technical report contains all material information. The advanced property definition doesn't change what the rule says, and the rule says all material information. The disclosure that triggered the report doesn't change what the rule says either. Regardless of the triggering disclosure, the technical report has to be complete. And remember that the report is supposed to be one-stop shopping. You can't incorporate parts of old reports by reference and then expect the reader to go back and decide which parts of an old report still apply and which are outdated. The new report always supersedes the old one, so it has to be complete in itself and not by reference to another report. And when we say complete and current, what does current mean? It's not the age of the report, but whether the information's still live. Prices or costs change, and that means that cutoff grades of a mineral resource change with them. Proposed programs get done, so once they're done, you need a new set of recommendations, or else there's no clear direction where that project is going to go without a new technical report. So some ways that a report might no longer be current: if there are changing economic constraints like stale price assumptions, if there are significant new exploration results, good or bad. Sometimes exploration programs are not successful. I once asked what happened to a company's inferred resource, and the boss said, "We drilled it." The recommended programs in the technical report might be finished, and then the technical report needs to show a new direction for the project. PEAs are another minefield. We had a bunch of bought deals that were derailed by non-compliant or potentially misleading PEA disclosure back in 2012. And they're largely defined by what they are not. They're economic studies that are not pre-feasibility studies or feasibility studies. So some of the hints that you've got a PEA rather than that are any study that puts inferred resources into the cash flow model, any study with a large margin of error on costs, any study that doesn't output mineral reserves, and then any study with multiple development options. You can look at a bunch of different development options in a PEA. You can't do that in a preliminary feasibility study, because then you're going to an actual reserve based on one single mining scenario. Well, we've got guidance from Staff Notice 43307 on what we consider to be reasonable and non-misleading disclosure of a PEA. And some of the things to avoid are Claiming that you have a PEA with inferred resources, but it's got cost accuracy comparable to a feasibility level study, you're essentially implying that you've got something that's just as good. You're just backdooring inferred resources into it when you shouldn't be. Implying by way of a production decision that a PEA effectively shows economic feasibility. We're not in the business of telling people how to run their company, but don't tell the investor that you're going into production on information that's equivalent to a feasibility study when in fact you don't have it. Any use of term like ore or mineable is going to tip us off that you're not really doing a proper PEA. Mixing reserves and resources in a single cash flow model, even a what-if cash flow model, is not a reasonable way to present a PEA. And making best case price or cost assumptions in a PEA when the real world is likely to be a lot less favorable to the project. Another pitfall is putting economic projections in your written disclosure, whether that's in a required filing or not. And we regard this always as disclosure of PEA. Where we see it most often is in investor relations materials, things like roadshow slides, fact sheets that get handed out of the PDAC, or on a company's website. If you're disclosing production rates, cost projections, cash flow projections, gross values, or third-party predictions like an analyst or a newsletter writer would put out, those are all economic projections, and if an economic projection is made, we expect there to be a preliminary economic assessment to back it up. In other words, a technical report that supports that disclosure. Another of the pitfalls is getting independence of the qualified persons right. The good news is that you probably don't need independence as often as you think. This is something a lot of people have wrong. NI 43-101 is not a requirement to have an independent QP looking over the company's shoulder 24/7. The bad news, though, is that when you do need it, there's no way around it. Independence applies only to technical reports. Routine disclosure, like news releases, MD&As, and the like, can always be approved by an in-house QP. But if you need independent QPs for your technical report, then you need them, no way around it, and they all have to be independent. One last thing worth knowing for prospectuses is that your mineral resource must have reasonable prospects for eventual economic extraction. And cool kids are calling that RP3E these days. This is a question of meeting the CIM definition of a mineral resource. And in that definition, it says that the resource has to have reasonable prospects for eventual economic extraction. Supportable product recoveries, plausible price assumptions, and plausible cost assumptions, those together make a reasonable cutoff grade, and that's what can tell you you have reasonable prospects for economic extraction. The supportable product recoveries, that means either evidence from metallurgical testing or else a good analogy from other truly similar mineral deposits. And pit limits and mine plans, they may not be essential for an inferred resource, but they're never going to hurt. And once you move the resource up to a more certain category, indicated or measured, it's very hard to do without a conceptual pit or mine design. And here's a list of the key staff notices for mining issuers. I draw your attention particularly to the second one on preliminary economic assessments, but they're all useful guidance in how to make sure that your disclosure doesn't raise any red flags for the regulators when you do go to file a prospectus. And with that, I will hand the discussion over to Dave Mendicino.
Thanks, Jim. I will now turn to the discussion towards issues that come up with prospectus filing involving dual-class share structures and restricted securities. As a starting point to the discussion on dual-class share structures in the context of prospectus filings, I would first like to do a quick run-through of what restricted securities are. So for purposes of National Instrument 41-101 and National Instrument 51-102, a restricted security means an equity security of an issuer that is not a preferred security of an issuer if any of the following apply. A, there is another class of securities of the reporting issuer that have a greater number of votes per security relative to the equity security. By way of example, this is what you normally see where there is a multiple voting share or some other security that has a greater number of votes per share than the common shares. The next example would be that there are conditions that attach to the class of equity securities or to another class of securities, or there are provisions in the constituting documents of the issuer that appear to nullify or to a reasonable person appear to significantly restrict the voting rights of equity securities. So the example for this case would be where you have common shares that have a limited ability to elect the directors of the issuer, where they might elect a subclass of directors or no directors, for example. And the final example of a restricted security would be where there's another class of equity security that has a greater right to participate in the earnings or assets of the reporting issuer on a per security basis compared to the owners of the first class of equity security. So this example would be where you actually have what an issuer refers to as two classes of common shares, but one of the classes has a greater right to dividends or liquidation right than the other. So as you can see from the definition, in general, a restricted security is an equity security, or more commonly referred to as a common share, but the rights normally associated with those common shares, such as voting and equity rights, have been diminished in some way by the existence of another class of voting or equity security, or by the terms of the constating documents of the issuer. And so I've referred to equity security in this definition, and that, again, you can generally consider what would normally be a common share of an issuer, and that's where they usually have the residual right to participate in the earnings of the issuer or the assets on the liquidation or wind up. Now, I'd like to mention at this stage that although not applicable to prospectus distributions, there's also Ontario Securities Commission Rule 56-501 that applies similar limitations on distributions of restricted securities, but those distributions take place via private placement. This will be relevant for the discussion later on in the presentation about applying for exemptive relief from the restricted security provisions. Now, to have a restricted security, there must exist another class of security that restricts or otherwise limits the rights of equity shareholders, and these are commonly defined as subject securities in the rules. Now, I'd like to note that preferred shares often have a superior or preferential right to dividends and proceeds of liquidation on the winding up of an issuer, for example, but these would not normally be considered subject securities. However, voting preferred shares could engage a restricted security analysis depending on the voting rights and other rights associated with preferred shares. So I'd like to point out as a general principle to the restricted security rules and the issues that come up with dual class share structures is that common shares will be considered restricted securities where there is another class of security that has a disproportionality between that class's voting and equity interest. And by way of example or summary, that's where voting control is held by a person or group of persons, notwithstanding that they hold a minority equity interest. So I'd next like to talk about what the impact of restricted securities are on prospectus offerings. So the main issue with the existence of a dual class structure has to do with the eligibility for being able to file a prospectus to issue restricted securities. And that's what we refer to as the prohibition on filing prospectuses. And really, subject to certain exemptions, an issuer cannot file a prospectus under which restricted securities, subject securities, or securities convertible into either types of those securities are distributed. Now, the first exemption that would apply is where an issuer was a private issuer before filing the prospectus. And really, this is basically the IPO of the issuer, meaning that if an issuer in its go public prospectus offering already has a dual class structure set up, the prohibition does not apply. The other exemption would apply where the issuer receives prior majority approval for the distribution of the securities in question. And I just note that this majority approval must exclude affiliates of the issuer or control persons of the issuer at the time of the approval. And finally, the other exemption would be that at any time the issuer had a restricted security reorganization related to the securities being distributed under the prospectus, that reorganization received the same shareholder approval that I've just described. Before moving on, I'd just like to give a brief summary of what we mean by a restricted security reorganization. And simply put, this is the event that results in the creation of the restricted securities, whether directly or through the creation of subject securities. This can include an amendment to an issuer's constating documents, a resolution of the board setting the terms of a series of securities of the issuer, and I'll note here a reference to what are called blank check preferred shares, which I'll talk about later, or another type of restructuring, arrangement, amalgamation, or similar transaction. And this also includes changing the terms of existing restricted securities without changing the voting rights of other classes proportionately. Now, to continue on with the discussion about the impact of restricted securities on prospectus offerings, once you've crossed the initial eligibility issue of whether or not you can distribute restricted securities through a prospectus, additional disclosure obligations will be required in the prospectus. These can be grouped into two areas. The first is just general disclosure, in which you will have to describe the limitations of rights of restricted security holders, and the other is nomenclature, which simply puts there's a prohibition on referring to common shares as common shares in the prospectus where they in fact restricted securities. you have to use another restricted security nomenclature, such as a restricted voting security, a subordinate voting security, or a non-voting security. The other thing that comes up in prospectus offerings may be where an undertaking is required with respect to blank check preferred shares. Now, when we refer to blank check preferred shares, this is where an issuer has an authorized share capital that includes preferred shares issuable in series, where the rights, restrictions, and conditions aren't yet determined and can be determined by the board at a future time. Where an issuer already has a class of restricted securities and has the ability to issue blank check pref shares, it could be that such issuance may further restrict the rights of existing restricted shares in the case, for example, where the blank check pref shares are issued with superior voting rights. In these circumstances, staff will request an undertaking from the issuer to provide staff with reasonable prior notice in the event that the issuer intends to issue a series of preferred shares that could further restrict existing restricted securities. Now, in addition to the securities law requirements relating to restricted securities and dual class structures in the context of prospectus offerings, I did want to note that in addition to those requirements, the stock exchanges in Canada have their own requirements as it relates to restricted securities and dual class structures. And these requirements are in addition to and more onerous than Canadian securities laws. For example, the TSX and TSX Venture Exchange each have their policies with regards to restricted securities, and staff understand that the Canadian Securities Exchange is applying requirements similar to the TSX and TSXV, although no written policy is currently in place. Now, just to give some examples of these additional exchange requirements, one such example is that an issuer would not be permitted to issue new subject securities, or in this example, multiple voting securities, unless they did a pro rata distribution of those securities to all equity security holders. Another example of these additional exchange requirements is the imposition of takeover bid protection, or what's also known as co-till provisions, which provide holders of restricted securities with the right to participate in a takeover bid for the subject securities. And absent this takeover bid protection or co-till provision, there could be a circumstance where a takeover bid is made for the subject securities, and there'd be no requirement under securities law for the restricted security holders to be able to participate in that takeover bid. And as a final note, staff may request confirmation from an issuer during the prospectus review that the exchange has approved the listing of restricted securities and the applicable co-till provisions that the exchange has requested. And as a final issue with regard to restricted securities and prospectus offerings, I did want to speak about the possibility for exemptive relief for these requirements. Staff have seen a recent increase in applications seeking relief from the restricted security requirements in National Instrument 41-101, National Instrument 51-102, and OSC Rule 56-501 in connection with proportionate voting share structures created for U.S. securities law purposes. Now, just to give a little bit of detail of what these structures look like, it's that they create a proposed class of proportionate voting shares where the voting and economic rights of these shares, such as the dividend right and the right on a liquidation, is, for example, 500 times that of the common shareholders. And in some cases, these proportionate voting shares and common shares may be interconvertible at a set ratio. And staff have been willing to recommend that relief be granted for these structures because, in essence, there is actually no disproportionality between the voting and economic rights of the proportionate voting shares. They are straight multiples of the rights of common shareholders, and so their equity and voting interest is actually the same as common shareholders. Now, as a technical matter, I'd just also like to point out, to make filing of prospectuses easier, is that the timing of when any application for this type of exemptive relief should be filed in the context of a preliminary prospectus. Generally, we would recommend that the application for this type of relief be filed prior to or concurrently with the filing of the preliminary prospectus for which the relief would initially be required. So, as I've noted in the slide, a decision document will be required in this context where relief is required from multiple national instruments in addition to National Instrument 41-101 because of the ongoing nature of the relief required. The relief under National Instrument 51-102 and OSC Rule 56-501 cannot be evidenced by the receipt for the prospectus, which is commonly the case where relief is only required under National Instrument 41-101. Now, although that National Instrument 41-101 relief could be evidenced by receipt on its own, in that case, the issuer would need to apply and pay the fee every time a prospectus is filed in the future, and that's why we recommend that the relief be granted in a decision document covering all grounds for relief. Finally, I'd now briefly like to discuss disclosure issues relating to Multilateral Instrument 61-101, protection of minority security holders in special transactions, in the context of prospectus filings. Now, generally, MI 61-101 regulates transactions that may raise conflict of interest concerns because the transactions occur between the company and its related parties. It is a significant rule in practice, and I'd note that it applies to all TSX, TSXV, and CSC listed companies. The rule is meant to protect the interests of minority shareholders when mergers and/or acquisition transactions are proposed in which a significant shareholder could have an advantage by virtue of voting power, board representation, or preferential access to information. The underlying principle of the rule is that all security holders be treated in a manner that is fair and that is perceived to be fair. So if MI 61-101 requires disclosure regarding a transaction, that disclosure must comply with the requirements of MI 61-101 and be included in a material change report or other disclosure document relating to a transaction that is filed on SEDAR. This disclosure document would generally be an information circular or other documents sent to security holders in connection with the shareholder meeting of affected securities, or if those documents aren't required, a material change report filed for the transaction. Now, in the context of prospectuses, inclusion of the disclosure mandated by 61-101 for a transaction in a prospectus alone does not satisfy the disclosure requirements of MI 61-101. They must be included in the disclosure documents I've just described. Now, as a final point, if the material change report or other disclosure document is not incorporated by reference into a prospectus, and for example, where you have a long-form prospectus and the issuer is not entitled to file a short-form prospectus, please note that staff may require that the 61-101 disclosure be included in a prospectus on the basis that it is material information. And now, back to Jeff.
Thanks, David. So why is the OSC focusing on reducing regulatory burden in the public market? Changes brought on by shifts in market conditions, investor demographics, technological innovation, and globalization all have changed our market and had a real impact on public companies. The pace of business is more rapid today. We've seen one of the largest financial crises ever, with one of the slowest recoveries. There have been shifts in demographics, with the boomers aging and their investment needs changing, and millennials choosing their own path as both investors and entrepreneurs. There is greater global connectivity, but we still have our own local market. And there are more choices today, more information available, and more innovation, leading to both opportunities and risks. As capital markets evolve, our approach to regulation needs to reflect the realities of business for Canadian public companies to remain competitive. The world we are living in is different from the one that existed 20 or even 10 years ago. It can't be business as usual. Both overregulation and underregulation can dampen innovation and undermine the competitiveness of our capital markets. Our rules should not add unnecessary costs. Rather, they need to be appropriate and balanced against the regulatory objectives sought. In April of last year, the CSA consulted on options for reducing regulatory burden for public companies. We published CSA Consultation Paper 51-104, Considerations for Reducing Regulatory Burden for Non-Investment Fund Reporting Issuers. We wanted to re-examine our rules through the lens of reducing regulatory burden to ensure they are still appropriate, necessary, and relevant. The consultation paper identified a number of options to reduce the regulatory burden associated with both capital raising in the public markets, i.e. prospectus-related requirements, and the ongoing costs of remaining a reporting issuer, i.e. continuous disclosure requirements. The options identified in the consultation paper were grouped into 5 categories: extending the application of streamlined rules to smaller public companies, reducing the regulatory burdens associated with the prospectus rules and offering process, which included reducing the audited financial statement requirements in an IPO, reducing ongoing disclosure requirements, including removing or modifying the criteria to file a business acquisition report, reducing disclosure requirements in annual and interim filings, or permitting semi-annual reporting. The final 2 categories were eliminating overlap in regulatory requirements and finally, enhancing electronic delivery of documents. In response to the consultation paper, we received 57 comment letters from stakeholders representing a diverse range of commenters, including public companies, investors and investor advocacy groups, law firms, and accounting regulatory bodies, stock exchanges, and industry associations. In addition, CSA staff also met with various stakeholders. In assessing the options, we took into account the need to prioritize options and focus CSA regulatory resources on projects that will provide the most impact in terms of reducing potential burden on public companies, are generally supported by stakeholders, and finally, are most achievable and within the scope of securities regulation. There were a number of options identified that we decided not to pursue at this time because they received little or no support from stakeholders or suggested significant disagreement among stakeholders as to the merits of the proposal. They appeared to offer less potential for meaningful reduction of regulatory burden on public companies. They were recently considered or are being considered in the context of another CSA policy initiative. Or finally, we identified substantive policy concerns or concluded that certain options fell outside the scope of our securities regulatory mandate. In March of 2019, we announced the outcome of our review in CSA Staff Notice 51-353. In the notice, the CSA publicly committed to initiating in the near term the following 6 new policy projects. First, consideration of a potential alternative prospectus model. Second, facilitating at-the-market offerings. Third, revisiting the primary business requirements. Fourth, revisiting certain continuous disclosure requirements. Fifth, removing or modifying the criteria to file a business acquisition report. And sixth, enhancing the electronic delivery of documents. Half of these projects relate specifically to prospectus requirements. Number 1, consideration of a potential alternative prospectus model. We're considering the merits of an alternative prospectus offering model for reporting issuers with disclosure more concise and focused than under the current short-form prospectus regime. Certain CSA jurisdictions have begun research as an initial phase of a project to explore potential alternative offering models. As part of this project, staff in such jurisdictions will consider any regulatory changes resulting from the separate CSA project to revisit certain continuous disclosure requirements already mentioned. Number 2, facilitating at-the-market offerings. While National Instrument 44102, called Shelf Distributions, establishes certain rules for ATM offerings under Canadian shelf prospectuses, NI 44102 does not establish a comprehensive framework for ATM offerings, as it does not exempt ATM offerings from certain provisions of securities legislation applicable to all prospectus offerings. Consequently, a reporting issuer wishing to conduct an ATM offering must obtain exemptive relief from certain securities legislation requirements. Some commenters observed that the limited number of ATM offerings in Canada may be partly attributable to a regulatory burden associated with the requirement to obtain prior exemptive relief and the conditions typically imposed in connection with such relief. Commenters also suggested that some of the current restrictions on ATM offerings could be relaxed or eliminated without compromising necessary investor protection and the integrity of the capital markets. In light of feedback that facilitating ATM offerings would be beneficial for Canadian reporting issuers, the CSA has initiated a CSA policy project in this area. And third, revisiting the primary business requirements. Several stakeholders suggested that CSA staff revisit the interpretation of Item 32 of Form 41-101F1, information required in a prospectus. These rules outline the historical financial statements required to be included in an IPO prospectus, and commenters noted certain inconsistencies between staff's interpretation of these requirements across the CSA. In light of this feedback received from stakeholders, CSA staff is considering ways in which we can provide greater clarity to issuers preparing an IPO prospectus regarding these issues. As a cautionary note, please keep in mind that there are a number of steps that must occur in connection with any changes to our regulatory regime, including securing Minister of Finance approval and publishing proposals for public comment, and, as a result, there is no assurance that any changes to our regulatory regime will ultimately be adopted. That being said, while it is still early days, we believe that we can find significant ways to alleviate burden in our public market. It is important for us to have a vibrant public market, and now is the right time to look at our regulations with this lens. I would like to thank Jesse, Lorraine, Evelina, Ray, Jim, and David for sharing their expertise with us today. Before we proceed to the Q&A, I'd like to draw your attention to slides 100 and 101, which contain contact information for today's presenters, among others. It looks like we have a few minutes for questions. Please note that while staff are happy to answer questions, this does not replace the advice of independent third-party advisors, as we are, of course, not the attendees' advisors. Also, as I mentioned at the outset, we'll be sending evaluation forms at the end of the session, and we'd appreciate your feedback, and we'll also be sending CPD certificates via email after the session. So thank you again for joining us, and please stay online for the Q&A, which will begin shortly. Please note that there may be brief delays as we review and respond to questions on a real-time basis.